This is a show that brings to the forefront newsmakers, entertainers, and those making a difference in our lives and in our world. Each week is a new adventure with topics ranging from the most serious and cutting edge to the most lighthearted and entertaining.
This is Taking Care of Business with Richard Solomon.
Greetings, everyone. Richard Solomon, Taking Care of Business. We are continuing our coverage on the coronavirus and providing our listeners with tools and information to support the community response to the pandemic we're all facing. So today we have noted attorney and a good friend, Lucy Berkman. She's up in Buffalo at the Lipsitz, Greene, Cambria law firm, lglaw.com. Her focus and concentration in the law is estate matters. And given the crisis that's out there, a lot of lawyers who are not in the estate field have been getting a lot of questions about what to do about this, what to do about that. And we tend to call our experts to help us along. So I thought that maybe we could bring that information straight to our listeners. So without further ado, welcome, Lucy. Thank you for being on the show.
Oh, thank you for having me.
All right. It's at lglaw.com. If you need to get their website, it's Lucy Berkman, Berkman. Okay. So there must be a lot of new adjustments being made to the way wills are being signed, executed, with all of the social distancing, with all of the people around the state in lockdown. And at least it seems to be that this is going to be the way it is for a while. What could you tell us about what's going on and how are lawyers working around some of the medical issues?
So, I mean, the good thing is that we've got some guidance that came out of the governor's office way back at the beginning of April. So when this first started. So since, March 20th, I've actually been working out of my home. My home is now my office with limited availability to come in to my physical office to look at files, take phone calls, things like that. So given that stance just alone, it's been, it's just been an adjustment on how we actually deal with clients, how we handle new cases coming in. So for instance, in my field with estate planning, estate administration, probate, I'm doing a lot of conference calls where normally for estate planning, let's say, for instance, I would be having people come in. I like to meet them face to face. I need to have that face to face interaction with somebody if I'm doing their estate planning to get to know them. I'm not able to do that really anymore. So we're doing everything over the phone, doing things by email, sending drafts out by email. But to get back to the governor's guidance, what the big problem is with respect to signing documents. How do we do that now? There's other states. Notarization. So there's other states that do have electronic notarization standards already in place, Florida being one of them. We don't have that. So what we need to do at this point in time is if we're not going to, be meeting somebody and maintaining social distancing with masks on, everybody using their own pen, which I have done, there is guidance to allow us to do things electronically by video conferencing. So it's a very interesting thing. Now, I haven't had an opportunity to do that. I almost got there this week, but I haven't yet. But here's basically what has to be done. So, for instance, if I'm witnessing and guiding somebody through signing, let's say a power of attorney, because wills are a different animal altogether. A power of attorney, I'm going to be acting as a notary on that document. So my client's going to sign it on a video conference where I see him actually signing it. He sees me, okay? What he has to do then is get me a copy of that signature page electronically, whether it's taking a picture on your phone and emailing it to me. That's fine as long as I can print it out. Okay. I countersign it then and send my signature back to him. So it's this multi-step process, but he can use that then on that original document as an original signature. What then has to happen, though, is I need the original document back with ink on it, his original ink on it, signature, within 30 days of signing it, and then I once again sign it, and I can notarize it and back notarize it, basically, backdate it. So it's kind of this multi-step process. Given my field, we have a lot of elderly clients. A lot of them do not have access to this video conferencing. They don't even have computers at home. Or if they do, they barely use email, So unless it's a younger clientele or a savvy, older person that's, quick with the computer systems and email systems of video conferencing, it's just really, to me, I'm not going to probably use it so much, unfortunately.
So wait, let me break this down. So
yeah.
I guess is FaceTime and Duo and those kinds of phone apps, are those okay as a video conference?
Absolutely. As long as you can see that person and see them sign the document, that's a key thing. So they can't just be you and I on the phone on our cell phones. Oh yeah, somebody telling me I'm signing this document. That doesn't cut it. You have to actually see them physically sign that document.
So would Zoom work also then?
Absolutely.
They just tip the
Zoom,
laptop.
Skype.
Yes.
Yeah.
They just tip the laptop sort of down a little bit so you could see them signing.
Yes. Yep.
Okay. I just wanted to ask because, all right, so can they convey the document by email, fax, or I guess text message?
Yeah, so email, so that could be them converting it to, scanning it in, converting it to a PDF on their own computer, sending me a PDF. It could be a fax over to my office and I go pick it up. Or like I was saying, to me, that could even be, I'm taking, I have so many clients that again, aren't that savvy with the computers nowadays. They'll take a picture of something on their cell phone and send that to me, as a text message or on an email. As long as I can see that, I can print that document out so that I can sign it, we're good to go.
All right. Now, I'm a fellow attorney, for those who are listening, and but I guess important disclaimer, we're not here to give legal advice to anybody, but we certainly want to give information to the general public. A lot of times I receive documents by text. They're very hard to read and they're very hard to print legibly. So I guess for people out there, if you can find a better way to do it. A lot of copy machines have scanning capabilities in them, at least the newer ones.
Right. And if it was, obviously, if it's something I can't read, I'm not going to be, countersigning that at all.
So let me ask you this question. You're in Buffalo and I'm here in Queens and I need you to notarize me for something. Does the notarization take place in Buffalo or in Queens? Oh, yeah.
Well, I'm signing it, notarizing it for you.
But what do you put on for the note? In other words, when you put State of New York, County of blank.
Oh, I would be putting County of Queens.
Okay.
It's because that's no different than me going up to. We have, Erie County. Buffalo is in Erie County. We're very close to Niagara County. I do work up in Niagara County. I do work down in Chautauqua, Cattaraugus, Genesee County. So all of this Western New York area. If I go to Niagara to meet a client up there on a normal occasion, and I'm notarizing, a document that they've just signed for me, it's going to be, State of New York, County of Niagara on there.
All right. So now let's bring this forward. As I remember from the bar exam, you need 3 disinterested witnesses to witness a will.
Actually, it's just 2. We just need 2.
Is it 2? But I guess they always use. I guess the better practice. It's good that you pointed that out. I guess the better practice is 3 because this way you have at least a spare in case somebody's invalidated. Yeah, and
I have seen that done on occasion too. A lot of times, people will do that. If it's let's say it's your executor who you've appointed under the will who's signing as a witness, or some other party who might be a contingent beneficiary or something like that. They'll have 3 on there. Generally, I'm just using 2, but we're completely disinterested because it's myself and maybe my secretary or my paralegal.
All right. So how does the signing and witnessing of wills work now that we can't necessarily be in conference rooms all next to each other?
Right. So it's kind of the same thing if you're going to be doing it as a video conference, okay? The will itself does not need to be notarized, okay? So that makes it a little bit easier. So, I mean, you can still do this by video conferencing. If I'm seeing somebody, a testator, we call them the person signing the will. If I see the testator sign it, we go through a set of, questions, standard questions that we ask someone. Is this your will? Are you revoking all prior wills? So on and so forth. They're going to be answering it the same way they would if it was a face-to-face, in-person meeting with them. They would, again, be sending me electronically what they just signed so that I can sign as a witness, and we have to go through that whole, kind of rigmarole again with the back and forth with this document. The interesting thing about the will is, generally when we're executing wills, we have both of our witnesses there at the same time, but actually, under statute, you don't have to do that. The witnesses can sign at different times. I don't think it's done frequently like that, but that is a possibility. So you could get into an instance where you've got a video conference with one witness at one time, and then the next day or an hour later, you have a video conference with your other witness. Okay. Again, it's just a lot of work involved with doing that. But I'm more concerned with something called a witness affidavit and a testing witness affidavit that us as attorneys, 90% of us, I'm sure, attach this to the back end of the will. And what that does is it just alleviates and streamlines things later on when we're going to submit this will to the surrogates court for admission formally into the probate system. It prevents us from having to track down witnesses 20 years after the fact or bring people in to testify that that's a valid will. So we have this nice little clean affidavit that's attached to the back end of the will. Under normal circumstances, if we've got everybody in the room together, us as witnesses, we're signing that affidavit right then and there. Okay. We're not going to be doing that necessarily with these video conferences, right? So I have to do it after the fact. And we have to tweak that and adjust the language in that now so that it accommodates the fact that, well, we saw them do this by video conference and they said this and that X, Y, and Z to me, and we're doing this in accordance with, governor's executive order, this, that, and the numbers. So it's just a little bit more difficult, but it is possible.
Is there any requirement that these Zoom things be recorded if it's practicable?
It's not, but it's probably a good idea because, and it's actually a thought that I had too, because if you ever got into a situation where it was a will contest, one of the things that somebody looking to contest a will, one of the ways they can attack that is, was it signed correctly? Was it executed correctly? So if you can record something and show that, well, yes, this person said that this was his will. I saw them. It's here on the video. It's just one more thing to boost and to bolster the fact that the will was executed correctly. So I do actually think that's a good idea.
Now, the problem is that certain modes of interactive video communication don't really have record buttons, and then storage is an issue as well. So, I guess all of this has to be worked out.
It does, yeah.
Do you foresee any innovative ideas that are going to come out of this? Because it looks like there's not going to be a lessening of social distancing for a while.
Yeah, well, I will give you a couple of examples of what I've done so far, and this isn't novel. I've heard of other attorneys doing this too, so it's not just me. I have had a couple will executions a few weeks ago, and what we did is we literally met on someone's front porch. We went through the documents. They signed it. We maintained social distancing. We all wore our masks, and we all used separate pens. And we were able to get everything done. The only thing, if somebody wants to do that, I'm more than willing to do that. The only thing I'm requesting them do is to bring their own witness. I just don't feel that, I should be asking someone from my own office to, necessarily put themselves at risk because I need them to witness somebody's will at their house, And I imagine that's a liability on our offices anyways. So if they bring their own witness, I'm okay doing that as long as, again, we maintain the social distancing, we're wearing the masks, and everybody's using their own pens. I'm okay with that, and that, alleviates this whole video conferencing, trying to email or fax documents or text documents back and forth. The only thing that the added thing that it results in is these witness affidavits, where normally if it's just myself and my paralegal signing this affidavit, I can get it notarized then and there. I can't do that because I certainly can't notarize my own signature. I'm not going to be notarizing the witness's signature either. So we have to do that after the fact, and I still have to tweak the language slightly on what we usually use in our office. But I mean, it's not that big of a deal. Let's put it that way.
All right. Let me ask you this question, or let me actually make a point here because I have about 2 minutes left in this section. Mm-hmm. A friend of mine, a longtime volunteer ambulance person, used to always walk around with his own pens, would never touch anybody else's pens, and would always tell me, don't use pens at banks, don't use the pen at the supermarket, just don't use anybody's pens because that is the greatest source of contamination. So when you say
that and elevator buttons.
Well, they're working on elevator buttons being somewhat contactless. But just to reiterate, when Lucy's talking about everybody's bringing their own pen, she isn't kidding, because I heard about this 20 years ago, but now it's a grim reality to look at your own pen. We only have
That's a great point. And when I've done these signings, I've actually, I went out right before the first one that I did, and I purchased a whole package of pens myself because I didn't know what people were going to be coming there with. So I said, listen, here's a free pen. It's not the greatest quality, but, just take one of these. And we lawyers in the estate world, too, we have a kind of a hang up with people using blue ink and the same pen, too. So at least if it's the same brand, we're okay. So, if I can bring my own pens and, they're clean, I know nobody's touched them, that's better. What we're trying to avoid at the end of the day is somebody signing in blank ink and then somebody else signing in blue.
Gotcha. All right. This is Richard Solomon with Attorney Lucy Berkman from the Lipsitz Greene law firm, lglaw.com. We're talking about estate issues during the COVID-19 epidemic, giving you some insights as to how the practice of law has changed and how social distancing has affected the signing of documents and instruments. We're going to be right back with more information. Keep tuned.
Hey, this is Johnny Rouleau, and you're listening to Richie Solomon on 88.1 FM WCWP.
Welcome back. Richard Solomon, Taking Care of Business, WCWP, 88.1 FM, Brookville, New York. Okay, so we're with Lucy Berkman. We're continuing our show on estate planning issues and the impact that the COVID-19 virus has had on the practice of law within the estate field. But what I didn't do, and what I would like to do right now, is kind of talk about all the different kinds of documents that are in play in the estate field. As I understand it, there's powers of attorney, healthcare proxies, living wills. We hear all these names. We hear them on television. We hear them in television shows and movies. But I don't know that there's a real understanding as to what these documents are used for, how they're created, why they're created, and what expires or how they expire, and what's revocable and things like that. So maybe you can give us a nice little summary of all those different documents, how they work and what they do.
Sure. So when we're thinking about estate planning, there's basically the three big documents that we're always really worried about and concerned about. One being the last will and testament, another being the power of attorney, and the third being your healthcare proxy, which I combine with a living will as kind of one document. So first, I guess I will touch on what operates out of those three, what operates while you're living? Because a lot of people have a misunderstanding of that in and of itself. So we've got a power of attorney and your healthcare proxy living will. Those are in operation while you are living. They do two completely different things, okay? The healthcare proxy and living will is pretty easy, okay? That is a document where you're appointing someone else to make medical decisions for you if you are incapacitated. So let's go back to coronavirus, okay? You're in the hospital incapacitated on a ventilator. You can't make your medical decisions. Who is your doctor going to go to? All right. Now, there is a statutory framework in place that your physicians, your hospital will look to if you don't have a healthcare proxy in place, and it goes in pretty much logical order. So you've got a spouse or significant other, your children, brothers and sisters, parents, things like that. And it goes along down the line. It ends up actually with your next close friend, believe it or not. But if you have a preference as to really who you want to make these decisions, you need to have that written down in a healthcare proxy, okay, that everybody knows about. So, for instance, sometimes I will have clients come in and let's say their spouse has predeceased them, all right, and they've got 3 kids out there. All right, they need to make a decision as to, which one of those 3 kids can sit here and make a tough decision, because really that's what it comes down to. When your physician's asking somebody else to make medical decisions for you, you can imagine what you are like in the hospital, right? So you need to have somebody in there that can make that decision. You can only have one person named at any given time for obvious reasons. You don't want people butting heads with each other. Well, mom wanted this or mom didn't want that. Nobody can make a decision, right? So if you have a preference, you are better off having that healthcare proxy in place. Again, that's the person making medical decisions for you in the event that you cannot, okay, you're incapacitated. And alongside with that is that living will, and what that does is it basically tells your healthcare proxy, your agent, your physicians what you do and you do not want in certain medical conditions. And generally it's something that's, an irreversible, terminal type illness, you're in a coma, your physicians really can't do anything else for you in terms of medical treatment. In this document, you can say, keep me on everything forever, for 2 years or, a month or whatever, or no, I don't want to live like that. You can just, let me pass away naturally. So that's what those 2 documents do. They work hand in hand with each other. All right. It's just healthcare decisions. The power of attorney on the
question.
Yeah, sure.
All right. So do the documents say anything about, if one or two or physicians state like in other words, what do the healthcare proxies base their decisions on? Is there like a rule it's got to be one decision or 2 independent physicians, or it doesn't matter? But how do they decide what to rule upon? Like, what's their source of their information?
Well, unfortunately, their source is going to be you. So you need to make sure that you have a conversation, with your healthcare agent.
I'm talking about the medical condition at issue. So it's strictly based on incapacity, and it's something that your physician makes note of that in your medical file. So, in other words, if you're sitting up in a hospital, maybe you're sleeping at the time the doctor comes in, he's not necessarily going to be asking your healthcare agent, oh, hey, am I supposed to do this or that, or put him in this surgery, or give him this drug or something like that. No, I mean, you're sleeping, you're not incapacitated. You've got to be really incapacitated. You're in a coma. You're on such pain medications. You're out of it. You can't comprehend anything anymore. Okay, it's really bad, and it's something that is that your physician makes a determination again, and it's noted in your medical record. And that's when they start asking your agents. Right now, but could you ask in this kind of document that your irreversible state is confirmed by more than one physician?
You could. So you could you basically, they're very tailorable to the individual circumstances. So I can tell you in my office, I have a general format that I use. that I will, present to a client. And, I say you need to make sure that you really read through this, obviously, to make sure it's what you want. And I've had on multiple occasions, conversations with the client who, geez, I really don't like this language. I don't want that language in here. I want this. And I have actually included language to that effect in documents before. So, it can be as simple as you want it or as extensive as you want it.
Okay.
There's no state form for something like this, in other words.
Okay, so where do you keep these documents before we move on to the next one? Because if somebody is in a coma, nobody can necessarily ask, hey, where's your healthcare proxy?
Right. So again, to me, it comes back to having a conversation with these people that you're appointing, whether it's the healthcare agent or even the agent under the power of attorney or your executor under the will. A lot of times, the clients will just say, okay, I'm going to tell these people where these documents are in my house. And they have full access to that. It's in this file cabinet over here. Okay. With something like the healthcare proxy, that's something you should be, giving to your physicians, whether it's your general physician or a specialty physician, when you go in to their office the next time, or make a special trip out there and say, hey, listen, I signed this. I need to have this on file with you. Otherwise, I leave it really up to the client. If they want to provide copies to their agents right away, they can do that. But again, I put that on their shoulders, really. That's not our responsibility. I don't feel personally as the attorney, I can only advise them as to what they can, what they might want to do. And if they want to go above and beyond, then, that's up to them.
All right. Question. When you use the word copies, do you need to have original copies or copies will work?
With respect to the proxy, it's going to be, again, in your physician's record anyways. If you have a copy, I believe that's okay. The power of attorney is a different thing, though. So let's say the client is going to provide their agent that they've appointed under the power of attorney a photocopy of that document. I always warn them that should not be accepted by anyone or any entity out there. It should be an original. Or it should be a clerk certified copy, meaning that entire power of attorney has been recorded formally in your local county clerk's office. Or it can be attorney certified. So I have a special stamp. You probably have one as well that you can affix to the document to say, "Hey, listen, this is a true and complete copy of the original," and I sign that and I sign off on that, and that actually counts as an original as well. So legally, under our statutory framework, those three are the only ones that should be accepted. So again, I go back to, okay, you need to have a conversation with your agent then as to, okay, where are you keeping this in your house? You don't want your agent to really have it in their hands right away, but it's over here in my house. You have access to it if you need it. Alternatively, and I can't speak for other firms out there and other attorneys, but we always have our clients sign duplicate originals. So we keep one on file here. So if something happens where we have a call from the agent, hey, something happened to mom, I need the power of attorney, I need the healthcare proxy, can you provide that? Of course, I'm going to do some due diligence behind that to make sure everything, I should be releasing that to the son or daughter, but that is a possibility as well.
Right. Now, I don't know that we got into power of attorney. I think we just went.
No, not yet.
So let's talk about that.
Okay, so the power of attorney is something, again, completely different from the healthcare proxy where you've got an agent making these medical decisions. Your healthcare or your power of attorney, I look at it as a business type document. You're appointing an agent to conduct business for you if you can't. And it doesn't matter if you're incapacitated or not. So that's kind of a key point to consider and think about, too, when you're signing these. So it could be under your direction while you have full capacity. As an example, I appoint you, Rich, as my agent, and I'm in Florida doing something on vacation. I say, gee, Rich, can you take my power of attorney and make this banking transaction for me? You'd be able to do that, okay? Otherwise, you can actually have language within the document itself. It's called springing language, where you can restrict your agent from acting only upon your written direction or upon your incapacitation, and then we delineate and describe when that actually occurs. So it could be by two physicians looking at you and determining that. Could be by a court determining that you're incapacitated. So I've added that type of springing language in, documents from time to time too. But generally, again, this is somebody who can conduct banking transactions for you, tax transactions. They can sell your stuff, sell your real property for you, conduct, if you own businesses, they might be able to step into your shoes and conduct certain business type transactions for you, speak to Social Security on your behalf. So there's this whole slew of powers that you can authorize an agent to do for you. And unlike the healthcare proxy, where we can only appoint one person to act at any given time, that's not the case under the power of attorney. So you could appoint 1, 2, 3 people to act jointly in concert at all times, or maybe you've got, again, 3. We'll go to the 3 kids example. Okay, one of them's here in New York, one's in North Carolina, and one's in California. All right, maybe we appoint them all as your agents, but really, we want the one in New York to be acting in the first instance, and then the second, and then the third. Okay, so it's a fluid document. It's very tailorable, again, to the needs of the client. I don't ever have one that looks like another. Let's put it that way.
Okay. Power of attorneys are used generally for non-estate stuff, more like transactional stuff, like deeds.
It's more it is more transactional. I don't want to go into too much detail because I think it gets you're too bogged down in them. But there's a lot of things that you can actually do with these. So 9 times out of 10, I'll be dealing with someone who is maybe in their 60s coming in to get this power of attorney drafted. They never had one before. Maybe they did. We're beefing it up now. There's a lot of additional authorizations that you can add into these documents to allow your agents to conduct extended estate planning for you, and also Medicaid planning. So we're worried a lot about Medicaid planning a lot of times. So we add specific powers into the document to allow for that to happen. So not only does it, cover just general, let's say, banking, because that's what, normally I think when people think of power of attorney, banking, they need it for banking, or real estate. But it can go beyond that and really cover a really broad scope, which I like to see, especially in the Medicaid planning realm, which we do, and I do in my office, because there's a lot of things we can do in terms of planning for assets, and it's usually the son or daughter coming in to act for mom or dad, in terms of this Medicaid planning. And if I don't have the requisite authorizations in the document, there's not much we can do for them. So
for those who are listening, what is Medicaid planning? What is that?
So a lot of people are worried, well, my goodness, if I'm in a nursing home, if I have to go into a nursing home for chronic care, how do I pay for that? I don't know what it's like downstate by you, but up here, you could be looking at, anywhere from $10,000 to, $12,000, $13,000, $14,000 a month for nursing home care. So how do you pay for that is always the question. And a lot of people do not have the assets, the underlying assets to pay for that. How do we do that? Well, we plead to the state and have them cover your cost under Medicaid. So in terms of asset planning, there's things that we look at, there's things that we can do, especially with real property in advance, to plan for, it just preserves certain assets in terms of Medicaid.
So it's basically asset protection. It's asset protection.
Yeah. It allows you to qualify for Medicaid. But again, if it's last minute planning, we call it crisis planning. If it's an agent, especially the agent acting, they don't have the power to do it, I can't help them. Or if someone didn't come in early enough, sometimes I can't help you.
Right now, what is early enough? What's the look back period?
The look back period is 5 years.
Wow.
5 years. Okay. So if we're going to be doing, planning now in terms of, let's say, we want to give our kids a sum of money, or we want to transfer a house to them, which is a big thing that we do. We have to be very cognizant, because if you're 80 years old and you come in and say to me, well, geez, I want to give my house, I want to do Medicaid planning, I want to transfer my house out to my kid today. And I'll look at that and I'll say, well, you're going to be taking a chance that you don't need Medicaid in the next 5 years, because the 5-year look-back period is going to be the date that you submit your Medicaid application to the state, or it's actually the local Department of Social Services. They'll look back 5 years. So we got to get past the 5 years. And at 80, do you want to take that chance? Do you want to take that gamble?
Hence the trip to the vitamin store.
Yeah.
All right. This is Richard Solomon with a noted attorney and friend, Lucy Berkman, with the law firm of Lipsitz, Greene, LGLaw.com. We'll be right back.
Hey, this is Scott Schedlinger, and you're listening to Richard Solomon, WCWP 88.1 FM.
And we're back. Richard Solomon, Lucy Berkman, attorney from Lipsitz, Greene up in Buffalo at 42 Delaware Avenue. They are at lglaw.com, and they are an incredible firm. And they have a lot of different departments, and I invoke my good relationship with Lucy Berkman to bring her on the radio and to talk about all the different estate planning tools and documents, especially in light of the lockdowns and problems that we're facing with the virus and the epidemic that we're all sheltering in place and doing what we can to keep ourselves socially distant. So we were talking about power of attorney, and that it's such a weird word because, you and I are attorneys, and yet the power of attorney in the document lets people do things that we can't do. Like, we can't just go up to a bank and say, well, look, I'm Joe's attorney. I'm going to transfer money from him. I'm his attorney, right? I have power of attorney, right? I'm his attorney. Look at e-file. I'm all over the place.
Yeah. So that's a great point to bring up too, Rich, because people get very confused over this, and I don't blame them. So I think if we just eliminate, don't think of it as your attorney that you're hiring, myself or you. And it's your agent, somebody who's stepping into your shoes to conduct activities you normally would be conducting yourself. I think that's the best way to look at it. And you can look at your healthcare proxy the same way. I don't like that word proxy either, because people don't, seem to understand that, or they get confused, as to what that means as well. It's your agent. It's somebody coming in to make these decisions, to conduct these transactions, these activities on your behalf. Again, either under your direction, or if you're completely incapacitated and can't do that anymore.
So we did basically say it's like a permission of authority or grant of authority.
Yes, yeah.
All right. So we talked about the living will. We talked about the healthcare proxy, and we kind of touched upon the power of attorney. So I guess those are all the documents that are in place while you're living. Somebody who is appointed under those documents act while you're living. As soon as you pass away, forget it. They can't do anything. Those documents are done. All right, but if you are brain dead, let's say, God forbid, you're still alive legally, right? Mm-hmm. Okay, so those documents are still in place. So those documents work until there's a certificate of death. Correct. Okay. So unfortunately, when that time comes, how does the will situation work?
Yep. So that's that's a time that we're looking to see, is there a will in place? If there is, we're looking to see, okay, who did you appoint in your will? Who did you name in your will to act as the executor? Again, another, legal term there. That's basically the person who's going to manage your assets after you pass away. gather everything, pay your bills, your debts off, and then distribute your property where it's supposed to go, either under New York state law or under the terms of your will, whichever is in operation at that time. So the importance of having that power of attorney and that healthcare proxy in place, I can't stress that, because there are so many times where people will come in, they don't have one or the other, and then it ends up being, I need to conduct a banking transaction for mom. She never had a power of attorney in place, and now, she has, far gone Alzheimer's. She's in the nursing home, and I need to do all this stuff. What do I do? You might be faced with a legal guardianship situation. You could have had a power of attorney in place years ago, and now your own family has to get legal guardianship over you for thousands of dollars. So it's not a good thing. So these documents are highly important to have, and honestly, at any age, too. You could be 18 years old, as far as I'm concerned, and you should have these documents in place. Apart from that, the will in and of itself is extremely important, too. And I will get people coming in and saying, well, everything's, jointly titled, husband and wife. And I say, well, that's fine, but what if you both die together in a car accident? Okay, that's one situation. Or I'm obviously always concerned about the last to die. Because now you've got everything individually titled. And while I may not have had to do anything estate-wise for you when your spouse passed away, because everything did pass to you, is all jointly owned, it's always the concern upon the last to die, too. And if you want your desires met in terms of who gets what of your property, then you need to have that down in stone in a will, because otherwise there's not a lot that we can do to help you after you pass away. So I get into this situation a lot of times where, people will wait until the last minute, and you and I were talking about this before we got on air. Just this week, I had somebody who was extremely ill in the hospital, not for coronavirus. It was just underlying health conditions that they were having problems with for months. But the goal was to try to get a will done for this person, basically on the fly while they were in the hospital, and certain circumstances surrounding, what they wanted in the will. I needed to hear this from the person, by phone or in the hospital in person, before I could get anything done in writing, and it just wasn't possible. The person ended up moving into hospice right away, and then passed away that evening. So, in here, there was an underlying concern about whether all kids were to inherit something or not. And, without a will in place, if really that was the person's intention, there's nothing that could have been done in that instance without the will, because under state law, all three children of the deceased person now inherit. So just by that example alone, I think that, impresses upon, everybody that you really need to get that document in place, unless you really don't care, which is a lot of people, they do have that attitude, funny enough, but no, it's an extremely important document. Going back to kind of, what we need in terms of getting that properly executed, it is, technically just the two witnesses who are disinterested, meaning they're not taking anything underneath that will. But as long as you have that, and you've seen or you've heard from the horse's mouth, the testator, that yes, this is my will, it's my signature there, you're good to go on that.
All right. So I watch movies from time to time, and you see things like where someone's in like I don't know, let's say they're in a boat, the boat's sinking, and the guy turns the recorder on and says, I'm not going to make it. So my Aston Martin goes to this one, and my jewel collection goes to that one, and blah, blah, blah. And then the tape washes ashore, of course.
Yeah.
And, some Boy Scout finds it and gives it to the right people. And, then you see this it all unfolds. Does that work in real life?
No, unfortunately, no, unless you're in war. If you're in war, it works, but otherwise, no. And going to the watching TV. Comment there. I often get calls about the reading of the will too. And there's no requirement that we bring everybody in the room and read a will all together in a room either. If the family wants something like that, we could accommodate, but I don't think that they're really going to want to pay for that at the end of the day either.
Yeah, it's so funny because soap operas are famous for those kinds of scenes where they're all gathered around seeing what they're going to get. They'll have, they're with great anticipation. What did grandfather, the CEO of this industry, who's getting the stock, who's going to be the next CEO, who's going to be the treasurer, and of course someone is always disappointed, and it leads to conflict and another season of drama. Right.
Yeah.
So that's actually not done in real life at all.
It is not done in real life. The best that we do is we will put people on notice that they're a beneficiary in the will, and that's it. And then they kind of wait it out until we're ready to make distributions at the end of there's a waiting period. But that's basically that's what you have. And I also want to caution, while I have this on the top of my head too, I caution people because, we have a lot of tangible objects, that we accumulate throughout our lifetime. And sometimes we want certain objects to go to certain individuals, and whether it's one out of the three kids. So, let's say I want all my jewelry to go to my daughter. My son doesn't care about it, but I want everything absolutely to go to my daughter. You want to make sure that you've got a will in place that provides that within the contents of the will as a directive to your executor too. You'll see sometimes in wills language about, I want my executor to follow the list that I leave with my will that says that painting on the wall goes to this person and my jewelry goes to that person. And they kind of just lump it all together. And I just caution people, and I always forewarn people that that's fine that you do that, but your executor in this state is under no obligation to follow that.
Oh, I didn't know that.
Yeah, so if you are steadfast, you want something going to somebody individually, just make sure that it's in the will. I always make sure it's a specific, it's called a bequest, specific bequest in that will. If it's something really nominal, like, I don't know, some
coffee
books
maker.
that are, or I'm not kidding you, I've seen plants. Somebody left plants in their will. I won't do something like that because I know at the end of the day when I'm trying to administer this through the court system, it just causes more paperwork. At the end of the day, quite frankly, I won't do that. I said, well, you can have your little list that says that. I don't think anybody's really going to fight over plants unless you have some sort of, fantastic orchid collection or some other exotic thing going on. That's a different story. But if it's just, your regular, your fern in your house, no, I'm not going to put that in your will.
All right, so we only have 6 minutes left. I want to do the lightning round of questions. So,
okay,
because I got a lot of questions to ask. So, going back to soap operas and movies and TV shows, someone's on their deathbed, and of course, what they do is they're like, son, here's the keys to the car,
yeah,
or the plane is now yours, whatever. Does that work?
No, and that doesn't work either because, and I don't know how many times we get that. Well, Mom told me I was going to have this. Is it in her will? No. Well, I'm sorry. Unless your brothers, agree to it, fine. That's all right. You guys can agree amongst yourselves. But if there's fighting, that's probably not going to happen.
All right. For let's say you have a number of people who are, I guess, what legally are called potential distributees, and some people are omitted. Are those the people that get a postcard saying that they didn't get something, but they may want to have an opportunity to challenge? How does that work?
Yeah. Okay. So that would be, if you're not being left something, you're being disinherited, then we know that there's a will in place. And what we have to do in order to get that will formally admitted through the court system, because here's another misunderstanding too. The will is out there. It's a nice piece of paper. It's executed. It's signed by your testator, your witnesses and everything. It doesn't operate. It's not fully legal until it's passed through the court system. And the court system says, yeah, that's a valid will. So what happens is even the person or the people that are disinherited, they do end up getting a copy of that will because we need them to sign a piece of paper that says, hey, I'm okay with that will and being disinherited. And if they're not signing that piece of paper, and then that opens up into court proceedings to contest a will if they so choose.
All right, so back to the movies again.
Yeah.
Child 1 gets, $100,000. Child 2 gets $200,000. But child 3, instead of being disinherited, gets $5. So, and then you see the shock and horror. And then the fancy lawyer says, well, you weren't really disinherited. How does that work?
They could still come in and challenge that will because, they have grounds to stand on perhaps, to say, hey, no, it wasn't executed correctly. And there is a presumption that it was executed correctly if it's under attorney supervision. But, they could say, well, geez, child number 1 and 2 exerted such undue influence over mom that, she was forced to sign that will, or maybe they promised her something if she signed it this way, or she didn't have the legal capacity to sign that. She was, far gone with Alzheimer's in a nursing home. So, they could potentially come in and still contest that will, even though they got the $5. Sometimes you'll see provisions in wills that discourage contesting of the wills, but you got to be real careful with the language because it still may allow somebody to come in under those specific grounds to throw the will out.
We only have like 2 minutes left, so that was just phenomenal stuff. I was just trying to think if there's anything that I could ask that's a really quick thing. But one thing that comes to my mind in the last minute or so is I've noticed that a lot of people don't do pre-planned funerals. Like they don't prepay them or get a plot. And then even though they've done all these legal things, they didn't do what was really necessary for their truly final disposition. Do you talk about that in another minute?
I do. Yeah. So it comes up a lot actually with Medicaid planning because it's a way to, if you have to spend down assets, you have too many assets to qualify for Medicaid, it's a great way to spend down your assets on something that's valid and will not penalize you for Medicaid purposes within that, even if it's done within that 5-year look back period, or even within a few months after your Medicaid application in certain circumstances. So this is a great thing to do. I always ask people if they have it, and I encourage them, if you have the funds to do it right now, think about doing it. Nobody wants to talk about death or think about themselves dying. And by going into the funeral director, obviously you're doing that. But I encourage people to do it anyways because you know what? Your family is going to be in this grief mode after you pass away, and it's one less thing they're going to have to really think about and sit down and think about. So if you have it all planned out for them, I think you're doing them a favor. So, twofold. You're helping your family during their time of grief, and you're also doing something that could help you in terms of Medicaid planning later on down the road, too. All
right. Lucy Berkman, attorney at law at 42 Delaware Avenue, Buffalo, New York, and lglaw.com. I can't thank you enough for your very valuable insights, your wisdom and expertise, and for being with us on the show today. Thank you.
Well, thank you.